All right. We are reconvening the Senate Committee on Judiciary. It is 7:26 on May 14th. I think it's still 2021. And I'm not sure if I don't think we need to take the roll again because we're just reconvening from a recess. Let the record reflect. All the senators are here. Most of us are here in the flesh, and we have one present with us by Zoom. Senator Harris, if you could just give us a shout or a wave or something to confirm.
Shout, wave, confirm.
Thanks. And with that, we are ready to finish off our work session. We have a lot of bills on work session. We have a number of them on a consent calendar. Then we will have a few more that are not on a consent calendar. I will hand it over to Mr. Guinan to walk us first through the consent calendar.
Great. Thanks, Chair. For the record, Patrick Guinan. As the Chair mentioned, we have a consent calendar. This is a different one than earlier. This is a consent calendar with several bills that have amendments on them. So for the committee's edification, the motion for these, if the committee is all still in agreement, would be amend and do pass as presented in the work session document. And the bills are as follows. Assembly Bill 42, first reprint, makes various changes relating to criminal law and criminal procedure. Assembly Bill 104, first reprint, revises provisions relating to wrongful convictions. Assembly Bill 132, first reprint, establishes provisions relating to custodial interrogations of children. Assembly Bill 202 in its first reprint, revises provisions relating to charitable lotteries and charitable games. Assembly Bill 237, first reprint, revises various provisions relating to real property. Assembly Bill 251, first reprint, makes various changes relating to juvenile justice. And Assembly Bill 394 in its first reprint provides that behavioral health specialists performing mobile crisis intervention services are immune from civil liability under certain circumstances. And that's it for the consent calendar, Chair.
All right, any questions on the consent calendar? Not seeing any, I will take a motion to amend and do pass these bills as read. I have a motion from Senator Settlemyer. I have a second from Senator Orenshaw. Again, because some of us are remote, I will ask that any discussion on the motion? All right, then let's do a roll call vote, please.
Vice Chair Cannizzaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemyer?
Yes.
Senator Hansen?
Yes.
Senator Pickard?
Yes.
Chair Scheibel?
Yes, and I will go ahead and assign the floor statements. I will take the statement on AB 42. On AB 104, is there a volunteer? I will give it to Senator Harris. On AB 132, is there a volunteer? I'll give it to Senator Orenshaw. On AB 202, is there a volunteer? I will give it to Senator Settlemyer. On AB 237, is there a volunteer? I will give it to Senator Hansen. On AB 251, is there a volunteer? I will give it to Senator Cannizzaro. And on AB 394, is there a volunteer? I will also give this one to Senator Harris. And that takes us through the consent calendar. We will now move on to our first bill not on the consent calendar, and Mr. Guinan will tell us what that is.
Thanks, Chair. The first bill that was pulled from our earlier consent calendar is the one we're going to do first. That is AB 141. This is a bill sponsored by Assemblyman Watts, and it revises provisions relating to sealing of records for summary evictions. This committee heard it on the 30th of April. The bill requires a court to automatically seal any records relating to any action for summary eviction that is granted during the COVID-19 emergency. These provisions apply to any action for summary eviction that's filed before, on, or after the effective date of the bill. There are no amendments.
All right. Any questions on AB 141? All right. No questions. I would accept a motion to
Do pass.
do pass. We have a motion from Vice Chair Cannizzaro. Is there a second?
Second?
We have a second from Senator Orenshaw. I'm guessing there's some discussion on the motion. Senator Pickard.
Thank you, Madam Chair. I appreciate what he's trying to accomplish, but we're talking about a fairly small number of cases given that the moratorium was in place. The evictions that were allowed to go through were for cause. And I think it would be a disservice to the community to seal the records when they're for purposes that were not simply because they couldn't afford it. So I just can't support this, so I'll be a no.
Understood. Any further? Senator Settlemyre.
Thank you, Chair. My other concern is that there needs to be some end in sight. So far, there is no end in sight to this emergency, and I'm worried that it's going to continue on as long as we continue to get money from the government. So for that reason, I'll be voting no.
All right. Any further discussion? Not seeing any, we will go to a roll call vote, please.
Vice Chair Cannizzaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes?
Senator Settlemyre? Senator Hansen? Senator Pickard? Chair Scheibel?
Yes. And with that, the motion carries. Is there a volunteer to take the floor statement? I will give it to Senator Cannizzaro. And that takes us, I believe, to AB 145. No, Mr. Guinan knows what we're doing.
Actually, that's my fault, Chair. I'm a little out of order because I was going to do the two bills that we pulled off the earlier consent calendar first. So this would be another do pass vote if the committee approves it. And this would be AB 398, which was pulled from our earlier consent calendar, if that's all right with you.
Yes.
Okay.
Thank you.
Great, thanks. Okay, so Assembly Bill 398, first reprint. This is a bill that revises provisions relating to the sales of residential property. It's an Assembly Commerce and Labor sponsored bill that we heard on the 27th. Excuse me, this bill prohibits the seller's agent from completing a disclosure form on behalf of a seller of a residential property. Agent's not liable to the purchaser if, number one, the seller is aware of a defect and fails to disclose the defect. Number two, the seller discovers a new defect in the residential property that was not identified on the completed disclosure form, or discovers that a defect identified on the completed disclosure form has become worse than was indicated on the form. And fails to inform the purchaser or the purchaser's agent of that fact as required. There are no amendments.
All right. Are there any questions on the bill? Okay. Seeing none, I would entertain a motion to do pass. All right. We have a motion from Vice Chair Cannizzaro and a second from Senator Orenshaw. I'm guessing there's some discussion on this motion. Senator Pickard.
Thank you, Madam Chair. Although currently inactive as a broker, I can tell you that sellers, when they're represented by a licensee, are required, the licensee is required by their current ethical duties to disclose what they know about a property. And this undermines that. It's going to create a problem for those licensees that don't, because they would be subject to discipline if they don't disclose what they know. And so because of that conflict, and because I think it's probably a mistake to take them completely off the hook, given that they are in a good situation, they're experts in the field, and they really are in a place where they're the ones typically hiring the inspection, and so they are privy to information that I think should be disclosed in the transaction, so I'll be a no.
All right. Any further discussion? Not seeing any, I will ask the Secretary to take a roll call vote on the motion to do pass AB 398.
Vice Chair Cannizzaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes?
Senator Settlemyre? Senator Hansen? Senator Pickard? Chair Scheibel?
Yes. And with that, the motion passes. Is there a volunteer to take the floor statement? Sorry, since you're not here to save yourself, it will go to Senator Harris. And
Happy to do it, Chair.
And I'll hand it back over to Mr. Guinan for the next bill.
Thanks, Chair. Patrick Guinan for the record. We're now on Assembly Bill 296, which was sponsored by Assemblywoman Wynn. We heard it here on the 26th of April in its first reprint. It establishes a civil cause of action for dissemination of personal identifying information or sensitive information under certain circumstances. This is the doxing bill. I don't know if I need to read the whole summary, Chair. I think I can just go to the amendments. The sponsor has proposed to amend the bill as follows. The amendment would remove the term mental anguish as a factor regarding liability. It would replace the word public with elected official to clarify the scope of the bill, and it would add to the exceptions for which no cause of action exists. Good faith communication in furtherance of the right to protest or the right to free speech in connection with an issue of public concern. So this was an amend and do pass, Chair.
All right, are there any questions on AB 396? Wait, I think I said the wrong number. AB 296. I don't see any questions, so I would accept a motion to amend and do pass. There is a motion from Vice Chair Cannizzaro and a second from Senator Orenshaw. Discussion on the motion. Senator Pickard.
Thank you, Madam Chair. I'm particularly distressed by the language for a couple of reasons. First, it essentially authorizes doxing of police officers when they're, I think the vast majority of them are trying to do a good job. It also implicates judges. Judges are elected officials, and they're already in danger because they make difficult decisions, whether they're in family court or criminal court or even civil court. I had a circuit court judge tell me once that a judge is lucky if 50% of the litigants dislike them, because if it's only 50%, they're doing pretty well. Usually everybody dislikes them for some reason. But it puts them in danger. This bill essentially, by excluding them, implicitly authorizes doxing of them. I just cannot support that, so I'll be a no.
All right, could we get some clarification from legal on whether the bill would protect behavior that, targets law enforcement officers with harassment and the like?
Thank you, Chair Scheibel. Yes, the bill as currently written would exclude law enforcement officers or an elected officer acting in an official capacity from the provisions, meaning that a suit could not be brought if an elected official or law enforcement officer was the victim of doxing.
All right, would the other provisions of law that currently criminalize sharing of that personal identifying information still apply?
Yes, that's correct.
Would you like to add anything, Assemblywoman Nguyen?
Thank you, Chair Scheibel. Rochelle, is this the right one? Yeah. Rochelle Nguyen, for the record, Assembly District 10. Yes, NRS 189.025. It's important to note that law enforcement officers, as well as district attorneys, as well as judges, as well as a ever-growing enumerated list, are already protected by Nevada law because it is already unlawful for them to share things like home addresses and photographs of officers. And so that is actually already criminalized. Again, this is just a civil thing. Part of the concern that I had when I took from some of the comments is I disagree. I don't think it specifically authorizes officers and judicial and elected officials to be specifically doxxed. I think those people are already protected. I don't know if that answers it. Again, that's NRS 189.025.
Thank you. Any other questions? Or, I'm sorry, we were in discussion. Any other discussion on, go ahead, Senator Pickard.
Thank you, Madam Chair. I think that the distinction is made, though, in that any action that is brought by those elected officials and law enforcement for civil actions are subject to anti-SLAPP litigation, and it makes it particularly difficult. So as a result, most of the electeds don't, because they could be forced to pay the other side's attorney's fees. And so this, I think, opens a window implicitly. And I recognize that it doesn't expressly authorize doxing, which I think would be contrary to public policy anyway. But I just think that because of the language of the bill, it's going to open the door to the interpretation that someone will use. And I just can't support it. Thank you.
All right.
Rochelle Wynn for the record. The other additional change is taking into consideration the testimony, I think the pretty impactful and emotional testimony from Heather Korbulik. The part of the other amendment to like specify an elected public official is because our public official is defined so broadly. I wanted to make sure that innocent people that didn't like voluntarily put themselves in a position where they ran for office or ran for judicial office were not included in that, just for the record.
Thank you. Seeing no further discussion, we'll go to a roll call vote on the motion to amend and do pass AB 296.
Vice Chair Canizaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre, Senator Hansen, Senator Pickard, Chair Scheibel.
Yes. And with that, the motion carries. Is there a volunteer to take the floor statement? I will give it to Senator Orenshaw. And that takes us to our next bill, which is AB 318. Nope, it's something else. And Mr. Guyan will tell us what it is.
Thanks, Chair. Patrick Guinan for the record. The next bill is AB 342, which this committee heard on April 27th. This is a Assembly Judiciary Committee bill on behalf of the Sunset Subcommittee of the Legislative Commission. Excuse me, and this bill makes changes relating to offenders. Do you want me to go through the whole summary, Chair, or would you prefer that we just go to the amendment? I think I can give you a brief one. This is a bill that provides that the Board of Parole Commissioners will only be responsible for establishing a program of lifetime supervision and establishing the conditions of lifetime supervision for an offender who's sentenced before July 1. There are lots of other provisions in the original bill. However, the amendment that we're looking at today, which is based on negotiations among all the stakeholders, is offered by this committee, and it proposes to delete all but Section 1 of the bill. And as amended, therefore, the bill would now require the board to conduct a review of its standards just once every 5 years rather than in each odd numbered year. And I would just note that the stakeholders are still in discussions and they have committed to continue negotiating, but they did want to go ahead and approve this part of the bill today, so it would be an amend and do pass as proposed. Chair.
Thank you so much. Are there any questions on AB 342? All right, I don't see any questions, so I would accept a motion to amend and do pass.
So move, Chair.
We have a motion from Senator Orenshaw and a second from Vice Chair Canizaro. Any discussion on the motion? Senator Pickard?
Thank you, Madam Chair. I just wanted to make the comment. I really do appreciate the stakeholders cooperating to include the DA's amendment. I'm still not particularly comfortable with the bill, but I think it's a lot better, and so I will vote it out of committee.
Thank you. And to clarify, the vote is to actually amend it in a different way and to remove all of the sections except for Section 1. So the change in the timeline so that they know so that the board no longer has to reevaluate its procedures every odd numbered year, but every 5 years would remain. And as Mr. Guinan stated, and as Senator Pickard pointed out, the parties will continue to discuss it because we realize that there are some improvements to be made with lifetime supervision. And there's just only so many hours in the day, as we've demonstrated today, to negotiate bills. With that, seeing no further discussion, we will go to a roll call vote, please.
Vice Chair Canizaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre, Senator Hansen, Senator Pickard, Chair Scheibel.
Yes. With that, the motion passes to amend and do pass AB 342. Is there a volunteer to take the floor statement? I will give it to Senator Harris. And we'll move on to the next bill.
Thanks, Chair. Patrick Guinan for the record. Again, we're now at Assembly Bill 396. This is a bill that we just heard in this committee today. It's an Assembly Judiciary Committee bill. This is a bill that makes changes relating to the use of deadly force. I don't believe that I need to go back through the summary of the bill again since we just heard it. The amendment is offered by Senator Harris, and it would remove Section 1 of the bill completely, and in Section 2, it would change the word "and" back to "or" as it was prior to the bill being drafted, so, or excuse me, prior to the previous amendment. So anyway, Section 2, change "and" to "or," and remove Section 1 completely.
Thank you. And before I go to questions on this bill, I do just want to acknowledge the sponsors. I see we have the Chair of Assembly Judiciary here. I also had a chance to speak with Assemblywoman Summers Armstrong, and I really, really appreciate them coming back to the table at a late hour to make an amendment to the bill that I think really improves it. It brings me into support. I'm proud to support this bill. I think it's important that we talk about the policy and do what we can to protect the public. And with that, I'll ask if there are any other questions. Senator Hansen.
Thank you. So with the amendment, everything that's redlined out now stays in law completely? Okay, all right. Well, it's a lot better than it was. I mean, that hearing honestly was a disaster in my opinion, and I'm very uncomfortable with the bill. I'm still going to vote no, but it seems like it's made it to where it's watered down to such a point that it's completely feasible. I don't think anybody, whether you support it or not, wants any rogue cops out there, want to have any excessive levels of force. But we've got to be a little bit reasonable in some of this stuff, and to constantly go after the police and, essentially constantly make them so that they can't make any decisions in the field practically without feeling like they're going to get an anal exam when it's all done is just going to completely harm their ability to do their job. So anyway, thank you, Madam Chair, for letting me have my say on that.
Absolutely. Any other questions or comments, Senator Cannizzaro?
Thank you, Chair Scheibel. I just again wanted to thank everyone for working on this because I do think there's been a lot of really good work done. Especially this committee has been working on Senate Bill 212, which I think is a good bill that's putting in place the right kind of accountability that we expect from our law enforcement while still allowing them to do their jobs and knowing. And I think this bill kind of takes us in that step to make sure that where there is an imminent threat, they have the ability to protect the public, and also building in those additional accountability measures I think are exactly what we have to do. So I'm very grateful for this, and I'm certainly grateful to Assemblywoman Summers Armstrong and Chair Yeager as well. I'll be supporting the bill.
All right, Senator Pickard.
Thank you, Madam Chair. I too am appreciative that the sponsors were willing to take one out. I still have an open question as to whether or not imminent would do violence to the intent of, the protection. So I want to talk to some experts, but I'll vote yes, but I'll reserve my right.
All right, thank you. And with that, I think we are ready for a motion to amend and do pass AB 396.
So moved, Chair.
We have a motion from Senator Orenshaw and a second from Vice Chair Cannizzaro. Any discussion on the motion? All right, we will go to roll call vote, please, on the motion to amend and do pass AB 396.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre, Senator Hansen, Senator Pickard, Chair Scheibel.
Yes, and with that, the motion carries. Is there a volunteer to take the floor statement? All right, I will give it to Senator Orenshaw. And that brings us to our next bill.
Thanks, Chair. Patrick Guinan. For the record again, we are now at Assembly Bill 400. This is a bill that revises provisions relating to prohibited acts concerning the use of marijuana. It is an Assembly Judiciary Committee bill that was presented here by Chair Yeager of that committee on May 12th. And we haven't heard this one for a while, so would you like me to go and read through it a little bit?
Yes, thank you, Mr. Guinan. And we do have Assemblymember Yeager here to correct me if I misstate anything. We've been discussing this up until this very moment, and I'm very grateful to Assemblymember Yeager for continuing to work with me on this bill. I think we have come up with an amendment that everybody can live with, and the amendment would include the amendments from the DMV that are currently reflected in the work session document, and whereas at the time of the hearing, Assemblymember Yeager presented to us an amendment that would create a rebuttable presumption of intoxication for felony level DUIs. The alternative that I'm proposing that we're proposing to the committee now would be that we would remove the per se levels for misdemeanor DUIs, but the per se levels of intoxication would remain in statute for marijuana for felony DUIs. For the edification of the committee, a DUI is a felony if it is the person's third DUI, if it resulted in substantial bodily harm, if it resulted in death, and I think those are the only circumstances under which it would be considered a felony instead of a misdemeanor DUI. And obviously, Assemblymember Yeager is here to answer any questions, as I am also happy to answer any questions, and we'll start with Senator Pickard.
Thank you, Madam Chair. And in your explanation, are those disjunctive? It's one of the above, it's ors? Okay.
Yes, that's
All right.
correct. Any of those three factors or three elements can trigger the felony adjudication of a DUI.
Right. And so what happens when we eliminate, on a practical level, what happens when we eliminate the per se levels on the misdemeanor charges? Is it merely then, are they too impaired? I'm thinking, the officer stops, does the field sobriety tests, and then what happens if we don't have per se on the misdemeanor side?
Thank you so much, Steve Yeager, for the record. Chair, through you to Senator Pickard. Much like we talked about the other day, everything would proceed almost exactly the same as it would proceed now. So they would do field sobriety tests. They could still take your blood, and then there would be a number, right? But the number would not be conclusive proof of your guilt. So at the trial, the prosecutor would have to prove beyond a reasonable doubt that you were actually impaired at the time you were driving. And so they would use all those factors that you just talked about, how you were driving, how you reacted. They could still use the blood test and the results of the blood test to establish that you had something in your system. They just couldn't rely solely on the number in the system.
All right. And would that result then in a jury instruction that said, well, the legislature has taken those out, and so we don't rely on those? What's the impact to the, because obviously what we don't want to do is increase the number of DUIs because police don't believe they're going to be able to get the conviction, or I'm sorry, the DAs don't believe they can get the conviction, and so they don't bring them, and so we end up increasing the number of DUIs. Just from a practical standpoint, how do you as a former defense attorney see that?
Steve Yeager, for the record, through you, Chair, to Senator Pickard. So the good news is the misdemeanor, maybe it's not good news. The reality is misdemeanor DUIs are solely bench trials right now. You don't get a jury trial, so it would be the municipal court judge or the justice court judge. So there wouldn't need to be an instruction given. They simply would know that, they can't sort of rely on this number. Now, obviously, I think we would be kidding ourselves if we didn't think that judges who have been there for a while sort of know what the number was. So, that's a factor for them to consider, but I don't think it's going to hinder DUI prosecutions. For the most part, from what I've been seeing on the ground, most of the misdemeanor DUIs tend to be multiple substances where you have alcohol, cannabis, maybe something else. So, I think in the case where you just have somebody who has cannabis, they would be able to get on the stand and explain their history of usage, why they feel like they can drive with a substance in their system, much like they might do with a prescription drug. And ultimately, it would be the judge who would decide whether the state has proved the case beyond a reasonable doubt. And then as just another matter, which many committee members here know, most of these things get negotiated. Very few of them actually go to trial. I don't think that would change. I think the only ones that would go to trial where there really is a dispute about whether the person was impaired, and maybe those numbers were pretty low, and then the judge would weigh it and decide whether the burden of proof had been met.
All right. Thank you for that. Thank you, Madam Chair.
Senator Settlemyre?
Thank you, Chair. I appreciate it. And this, of course, still includes the DMV amendment, because clearly you have no choice when it comes to CDLs. There's a zero tolerance policy. And so, I don't know, I think it's an interesting compromise between the laws that exist for DUI. It's a pretty decent compromise in that respect for, regular drivers. But again, on the CDLs, there is an absolute zero tolerance. And I always question the concept of creating different classes. If you're a CDL, okay, here's your rules. But we already do that in the realm of alcohol when it comes to drivers on CDLs. We also do the same thing in relation to concealed weapons carry permits when it comes to individuals as well. There's a whole different level. So I don't know. I appreciate the amendments that are done. I'm still trying to wrestle with it a little bit, but thank you.
Sure. Any other questions? All right, then I would accept a motion to amend and do pass.
So move, Chair.
All right, we have a motion from Senator Orenshaw and a second from Vice Chair Canizaro. And any discussion on the motion? All right, we will go to roll call vote, please.
Vice Chair Canizaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemeyer, Senator Hansen, Senator Pickard, Chair Scheibel.
Yes, so the motion passes to amend and do pass AB 400. I will assign the floor statement to Senator Harris, and we'll move on to the next bill.
All right. Thanks, Chair. This is Patrick Guinan for the record. We're on Assembly Bill 424 in its first reprint now. This revises provisions relating to pretrial release. And this is an Assembly Judiciary Committee on behalf of the Pretrial Release Interim Study. AB 424 removes the requirement that an arrested person show good cause before being released without bail, and instead provides that a court may only impose bail or a condition of release or both on a person if the imposition is necessary to protect the community and to ensure the appearance of the person in court. There are a couple of amendments. The first was presented by Senator Harris at the hearing on the bill, and I don't know if the chair needs me to go through those again, or if you just want me to discuss the new amendment that's the committee's amendment. Okay. Anyway, for the members and for those looking on from wherever you are, the first set of bullet points is the amendment that Senator Harris described, and that's attached for your review if you need to. The second amendment begins at about 3/4 of the way down the page. This committee proposes a conceptual amendment intended to conform the provisions of this bill with Senate Bill 369, which addresses many of the same elements of pretrial release. The amendment is drawn from the mock-up provided by Senator Harris, and it is attached. The additional revisions are as follows. It deletes several provisions concerning when a person is entitled to a pretrial release hearing. It changes the term accessible to available regarding certain documents to be provided to the accused, and it adds language clarifying the informal nature of a pretrial release hearing and that more than one party may be involved and have certain rights at that hearing. And that's all, Chair Scheibel.
Thank you very much. Are there questions? Senator Pickard.
Thank you, Madam Chair. I'm just wondering if my biggest hangup has been the 48-hour hearing time. And I know that the second bullet point says, provides for a continuance for good cause shown. And one of the things that was presented was that sometimes it's the state doesn't have time to pull these things together in 48 hours. Sometimes, that 48-hour window will fall on, early morning of a weekend. And that sometimes the DAs aren't able to get in communication and be prepared for those hearings. So is good cause shown, what does that entail? Is that anybody, for any reason that it isn't just a delay tactic, they get to take longer? Does that require a hearing? Does that require, the judge's intervention? How does that work?
So that it would be a decision by a judge to grant a continuance for good cause, and good cause does appear elsewhere in the NRS, and it is, of course, I don't want to say it's a term that is interpreted over and over, and certainly parties do argue about what constitutes good cause, and that's totally appropriate. But from a process standpoint, what that would look like would be either party communicating with the judge, and it could be in a formal or informal manner saying that we are requesting some additional time before this hearing for a particular reason, and then the judge saying okay and providing them with a new date. So that could be having all of the parties on the phone. It could honestly, if the jurist, Mr. Anthony can correct me if I'm wrong, but if the judge allows it, it could be via email, it could be by agreement in advance, as long as the judge makes a determination that there is good cause and gives a new time and date for the hearing.
All right, thank you. I just want to make sure that those counties that just don't have the resources don't get themselves in trouble, and this gives them the authorization to do that. My second question has to do with Section 4.7 of the mock-up. It's requiring that the person being released sign a document stating that they're going to appear at the times and places required and on. And I'm wondering, for those that really we're worried about those that just are not going to appear. I'm wondering whether or not we have any data. I know our defense counsel are here. Maybe they can tell us what their experience has been if the chair wants. But how many times do people sign these documents and then fail to show? What I'm getting at is this kind of a meaningless requirement if these people aren't going to show on a regular basis, or if signing a document is actually effective.
So I can speak to part of that question and say that I think the main purpose of signing the document is ensuring that the person has been informed of the next time and place that they have to appear in front of the court, so that there's no question about whether or not they knew the next date. If they've signed a document stating that they know when and where to appear, that is one check to make sure that they do know that. And I think for that reason alone, it is worth keeping the language.
Sure, and I'm not suggesting we remove it. I was just wondering from a practical standpoint, how effective is it? And I recognize under 4.9 it actually specifically gives the court grounds for a contempt under 22010. So there's certainly teeth to it. I get that. I was just wondering if that's even effective in a real world scenario, but that's not going to obstruct me from supporting the bill, but just wanted to ask those questions. Thank you.
I also think that currently everybody has to sign one of those documents, so it would be hard for us to establish a percentage success rate because everybody does it. So it would just be whatever rate at which people fail to appear for court would be the failure rate of people who sign the document. You can't really compare it to people who don't sign the document because there are no people who don't sign the document, unless Ms. Birchie is going to school me on document signatures before release.
Kendra Birchie with the Washoe County Public Defender's Office. It's my understanding that currently we don't, at least in Washoe County, require everyone to sign these documents. It's if they're being released with pretrial services. However, I would just note to your question, as we've spoken to this committee before, we don't keep this data. This is why one of the recommendations from the pretrial or the release committee was to actually track this data so that I could sit here with an answer for you. But unfortunately, we don't have that data, and so that's another bill, and I hope that does pass out of finance. Thank you.
All right, thank you for that. I appreciate it.
A much better answer than I gave. Thank you. Any other? Senator Settlemyre.
Thank you, Chair. I'm still very concerned. I wish we could have gone to the concept of 48 judicial hours. Some of the smaller counties that I deal with had some serious concerns and reservations about that, especially in relation to large-scale events, as I brought up on the record. Creates a situation where some of these communities maybe have 5 cases a week, yet Burning Man produced 50 a day. And that type of large increase makes it very problematic for them in that respect, and that's why they were kind of seeking that type of clarification or flexibility just based upon the circumstances. And as we've seen in recent history, sometimes things happen where courts get inundated due to the actions of individuals, and therefore I cannot support it. Thank you.
All right. Other questions? Senator Hansen.
Not so much a question, just a statement. I really like the bill. I actually read Valdez Jimenez, and I agree completely with the points that have been made. Talked at length with Senator Harris about it, and was completely in favor of it till I heard all the testimony from the rurals. And I think there's still some really significant issues for them. Even with the amendments, I mean, some of this just makes them they just flat don't have the resources to do some of this in the time frame. And it seemed to me, too, the main testimony indicated that the bigger problems are actually in Washoe and Clark counties more so than in the rurals. So I'm not going to support the bill. I support the concept 100%. But after hearing that testimony, I just can't do that to the rural counties. I just flat don't think they have the resources financially. Even the number of lawyers that are available in some of the counties to act as defense attorneys and so forth was minimal. So I will be a no reluctantly, and I hope we can work out some of the arrangements, because I agree completely with the concept that you're innocent till proven guilty, and if you're flat unable to afford bail, it is in effect an unfair incarceration, and you have no ability to even prepare your own defenses in some cases. So I'm sympathetic, but I'm going to have to be no because of the impacts on my rural counties. Thank you, Madam Chair.
All right, Majority Leader Canizaro.
Thank you, Chair. And I just wanted to thank you for working on the amendment, and Senator Harris for working on not only the mock-up we got in committee, but also the proposed conceptual. I am still trying, I think, to compare this one to 369, just to make sure that what we have makes sense from a process standpoint, and then from a legal standard standpoint. I think we are very close. I'm going to support this because I do think that's what this is accomplishing, but did just want to make a note that if we need to make some adjustments so that the two bills make sense together, that may be the case.
Thank you, Madam Majority Leader, and I'll echo those comments. And I also want to thank Senator Harris for many tireless hours of work on this, along with other stakeholders. And indeed, we are only human, so as we move forward in this process with additional reprints and comparisons to SB 369, we will ensure that they match each other. There may be additional floor amendments for that purpose, and also, if anybody else sees anything in the bill after this work session, I know the hour is late. I don't want you to think that that my door is closed. And with that, if there are no other questions or comments, I will entertain a motion to amend and do pass AB 424.
So moved, Chair.
We have a
So
motion.
moved.
We have a motion from Senator Orenshaw. I'll give the second to Senator Harris and ask that the Secretary please take a roll call vote.
Vice Chair Canizaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre, Senator Hansen, Senator Pickard,
I'll be a no, but hopefully I can change by the time I get the word back from the rural judges.
Chair Scheibel.
I am a yes. And with that, the motion to amend and do pass carries. I will assign this floor statement to Senator Harris. And that brings us, I think, to our last bill. I finally got on the same page as Mr. Guinan. We have one bill left, and he will tell you all about it.
Thanks. Excuse me. Thanks, Chair. Yes, this is the last bill before the deadline. So we are at AB 440 in its first reprint. This is an Assembly Judiciary Committee bill, again on behalf of the pretrial release study. And this one relates to the issuance of certain citations. And we heard it here on the 12th of May. This bill requires peace officers to issue misdemeanor citations, traffic citations, vessel citations, and wildlife citations for offenses punishable as misdemeanors that do not constitute repeat offenses or crimes of violence. Additionally, the bill specifies circumstances when a person must be taken before a magistrate if the officer has reasonable cause for believing that the person has committed certain offenses. Senator Harris has proposed an amendment that is attached. The amendment replaces references throughout the bill to quote-unquote crime of violence with the term prohibited crime. And then it defines prohibited crime as a violation of a temporary protective order, driving under the influence, stalking, and includes the current definition of a crime of violence. And the amendment also clarifies that the intent of the bill is to apply to traffic misdemeanors and would not include DUI and vehicular manslaughter. And that's it, Chair.
All right. Any questions on AB 440? Not seeing any, I would Not seeing any, I would entertain a motion to amend and do pass AB 440.
So moved, Chair.
We have a motion from Senator Orenshaw and a second from Vice Chair Canizaro. And is there discussion on the motion? Senator Canizaro.
Thank you, Chair Scheibel. And I wanted to thank Senator Harris for working through some language on some of the amendments. I appreciate what the bill is trying to do. I did think that there were some cases where I don't think that a citation is appropriate in a lot of those instances, and so this would allow for that to still be something that could be arrest. Things like violating protective orders, stalking, some of those other misdemeanor crimes that I think can actually be more inherently dangerous than some of the other ones. And so I think for the purposes of this conceptual amendment, making sure that we can include those and and make sure that we have the ability to mitigate what can often escalate into very dangerous situations ahead of time before they become more serious, I think is important. And then also when we were looking through the language, some of this, because of the way that the traffic statutes are written, was applying to some things that I think probably wasn't intended to for citations, where we don't issue citations for certain felonies and other things. And I appreciate her willingness to talk about things like DUI and vehicular manslaughter, mostly because I think the victim families should be part of those conversations before we do something where you could, negotiate or plea in the case on a system. I think those conversations are important for those victim families. So I appreciate the conceptual amendment and just wanted to thank Senator Harris for including that, and I'll be a yes on the motion.
Thank you so much. Any other discussion? Senator Pickard.
Thank you, Madam Chair. I completely agree with everything Majority Leader just said, but I'm on the other side of the fence, so I'll be a no for those reasons until I can see the language. Thank you.
All right. Senator Hansen, did you have discussion? Okay. Seeing no further discussion, we will go to we did have a vote, or we did have a motion, right? Okay. We will go to a vote on the motion to amend and do pass AB 440.
Vice Chair Cannizzaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemyre? Senator Hansen? Senator Pickard? Chair Scheibel?
Yes, and with that, the motion to amend and do pass AB 440 passes, and I will also assign this floor statement to Senator Harris. I believe that takes us, to the end of our meeting, except that we still have to accept public comment. Is there anybody in the room to give public comment? I don't see anybody in the room to give public comment, so we will go to the phones. Is there anybody on the phones to give public comment? And actually, I think we have Ms. Ferguson with us. Whoever might be out there.
Thank you very much, Chair Scheibel.
It is Mr. Kyle.
I'm still here. We're not testifying. We are currently on public comment. Excuse me. If you would like to provide public comment at this time, please press *9 now to take your place in the queue. Once again, to give public comment this evening, please press *9 now to take your place in the queue. Caller with the last three digits, 037. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. Over the years, Nevada has created some wonderful legislation on criminal justice reform. There are still some areas where the law needs to be revised, starting from the ground up. These areas deal with the district attorney's office and their qualified immunity, prosecutors committing Brady violations without having any repercussions for them. When a prosecutor withholds evidence at the expense of an innocent person, they must be held accountable for their actions and not protected by their own. Another area of criminal justice reform revision needs to be changing the statute of limitations, particularly dealing with perjury. If perjury is committed and a person is convicted, incarcerated, and continues to be incarcerated or dies while being incarcerated, the statute of limitations do not apply. Charges should be brought against them. When a public official, including the district attorney, hinders or delays an investigation that results in no formal charges being filed against the person who has committed perjury that resulted in the person's incarceration or continued incarceration, will be held accountable for their actions. District attorneys need to be held accountable for the harm they have caused to others in order to get and keep a conviction. My hope is that in 2023, our legislatures will look into making our criminal justice reform complete by creating new laws. Thank you. Have a wonderful evening.
Thank you, caller. Caller with the last three digits, 556. Please slowly state and spell your name for the record. You'll have 2 minutes. You may begin.
Anne Marie Grant, ANNEMARIE GRANT.
This session, I have asked you to hold police accountable, and some of the bills passed out of this committee are a step in that direction. I would like to see the focus next session remain on police reform, but also consider holding prosecutors accountable for their actions. We need to take away qualified immunity. I have listened to not only this committee's hearings, but others over the session, and over I have heard the DA's response that we have a policy for that to any type of legislation that would provide oversight of them. Policy isn't law, and it's much easier to say we are following our policy than to have mandated legislative oversight. When Brady violations were brought up in one hearing, the DA's representative acknowledged that there are no true consequences when DAs withhold evidence. Basically what the response is, well, we just never would do that. We would never defy a Supreme Court order. The personal assurance from other DAs that nobody from their office would do anything to jeopardize their good standing just isn't sufficient insurance for the community that justice is truly just and fair. The resistance is concerning. I personally know of a case that a court-appointed attorney in the post-conviction hearing provided poor, inadequate performance. He did not notify the defendant he was representing that he had accepted a job within the appellate division at the Washoe DA's office. The attorney attended the hearing. He accepted the job weeks before the judge issued the order. The attorney went to work for the very unit the defendant was going up against at the hearing. That is unacceptable. I'd like to see legislatively mandated wrongful conviction units. The Washoe County CIC has reviewed one case since inception and chose to only look at court orders when they should be looking at the defendant's pleadings. If the CIC lead member stated in that case the CIC cannot offer a more thorough assessment of your claim than the 12 citizens that served on a jury that didn't get to see all of the evidence, by the way. So if that's their position, why even have a CIC? It appears to be a dog and pony show and further proof as to why we need legislation on this. If you as the legislature
You've reached about 2 minutes. If you could please wrap up.
They never will be held accountable. Thank you. Have a nice weekend.
Thank you, caller. And with that, Chair, there are no more callers to provide public comment at this time.
All right, thank you so much. That brings us to the end of our meeting. I will be very quick. There are just a couple of people that I want to thank for getting us through to this deadline day. And actually, I hope Ms. Brown and Ms. Grant are still around, because I also want to acknowledge that we are all dedicated to doing good in our own way, and they choose to join us in these meetings almost every single day. And I'm very impressed that at this late hour, both of you have continued to follow what's going on in the legislature. You're not elected to do it. You're not paid to do it. You do it because you believe in something. And I think that's admirable. And I thank you for engaging in this process with us. And that is only possible because we have amazing staff here. I have kept the legislative police here late tonight. I have kept the Sergeant at Arms here late tonight. Our Committee Counsel Nick Anthony is here late tonight. Our Secretary Gina LaCascia is here. Patrick Guinan, our committee manager, Beth Rikers, has been working really, really hard all day on her feet, getting things done for us. Plus, we have amazing staff at Broadcast. Sierra Ferguson, Jen Wells, and Bryce Kyle have all been here for over 12 hours now to help us get through this deadline. So my deepest gratitude to all of you and my committee. I know that you have been working hard here in Judiciary and elsewhere in the building, and it's an honor to serve with you. We're not done yet. We still have some exempt bills to hear next week, but we will not hear them on Monday. So we will be adjourned until Tuesday-ish of next week. And we are adjourned. Have a great weekend.